Thank you, Ms. Freiberg, for being here, and for our chairman, Mr. Cry, for joining us as well. We'll move now at this time to the approval of the agenda minutes, our first item. Can I have a motion to approve these minutes? We've got a motion by Commissioner Alford and a second by Commissioner Hughes. All in favor, those say aye.
Aye.
Okay, motion passes 5-0. Let's move into the agenda items. Our first item, Agenda A, the public nuisance abatement consideration. You have those documents on page 3 through 6. At this time, I'd like to ask Ms. Freiberg if she'd like to offer comment on agenda item A.
Yes, and I guess I first want to start by saying this one's a little bit unusual. You all have before on multiple occasions dealt with cases coming out of environmental court. That is not what this is. This is a case that came out of our circuit criminal court as a public nuisance. So the public nuisance statute is separate and apart from our environmental things. It gives the district attorney's office the authority to prosecute that. So that's who was prosecuting this case. The address is 1770 Spring Place Terrace, and there was a court hearing on this. I will say this property had been environmental court, I believe, on 2 separate occasions years ago. And so we did take it through that process, and I think at one point they put up a privacy fence, but we had not gotten any complaints on it. But obviously the public nuisance concept is different. So in environmental court, you're looking at debris and garbage and refuse and things that we are regulating. Public nuisance is different than that. You're looking at, calls from law enforcement and criminal activity on the property and all those different things. So there was a hearing on this property. I think originally on August the 5th, they went through all that, and the court found the property to be a public nuisance. At that point in time, they were trying to figure out what to do about it and how to get the property cleaned up, and that is the point that I was asked to go to court on it. And so I did. This order came out of that court hearing, which was when I asked them, the court, not to make it mandatory that the county clean it up, but to give us authority or permission to go in and clean it up. Simply because it hadn't been funded, you all hadn't discussed it, and so that's where we are. We do have another hearing, if you look, which the court is hoping to get a response, I guess, from us, or what we plan to do on December the 12th to figure out where to go from here. But if you look in the order, it's permissive language. It does allow us to go onto the property and clean it up. It does allow us to put a lien on the property if Mr. Ratcliffe does not pay the county's costs. I do think that this would qualify for use of landfill funds. However, it does not meet our resolution that we've passed for use of those funds where there's no heirs to be found. There is an heir on this property. In fact, Mr. Ratcliffe is an heir. The property actually is in the name of his deceased parents. So he's an heir who has lived on the property, and he's the one who has caused the public nuisance to exist on the property. He's also incarcerated in the Bradley County Jail currently.
You answered my question. I was going to ask is he living in the property?
He was prior to his incarceration.
He just has a new address now.
Correct. So I can certainly answer any other questions, but that's.
And I believe we'll draw attention to items 7 and 8 on the court order that tells us the respondent shall be assessed and responsible for all costs incurred by the Bradley County for abating the public nuisance. And if he fails to pay the cost in item 8 incurred, that we are authorized to pursue the order to place a lien on subject property. So, yes, Commissioner Hughes.
Crystal, that order to pay it, can that be handled as a restitution, where he'd pay it back as a restitution, or is it straight to us? And the other question is, I believe there's 2 different lots there. Does that have both lots or just that one?
We did have the order include both lots, and you're correct, there are 2. Unfortunately, no. If there's not any restitution that can be ordered because So I think the best that we can do is if he doesn't pay it, and I will tell you, this is just my opinion, but I think the chances of Mr. Ratcliffe paying for the cleanup out of pocket, if we were to do it, is very slim. So I do think our recourse at that point would be to put a lien on the property. I will tell you that the financial danger of it and the reality of it is that if we put a lien on the property that makes it higher than the value of the property, we will make it hard for it to sell, and you can't get your money back. If the amount of the lien you put on the property is more than it's worth, you won't ever see that. So I certainly can't tell you that we will recoup it. I can tell you that we'll put the lien down, and we'll make sure that if and when it gets sold, we would get whatever there would be.
Do we have any estimates on that?
We do not. No, this is the first time this has been brought up, so no, I have no idea at this point how much it will cost to clean up. And it's bad. I will tell you, I've seen some bad ones, and this one's bad.
Recognize Commissioner Slater, then Commissioner Alford.
Do you know the value of the property?
I believe Stanley has it assessed at, I'm not positive, Commissioner Slater. I believe it was around 18,000, but that seemed a little high to me. And there are two parcels. I think that they're looking at it because there are structures on it and assessing it based on there being structures, but these structures are not. They are not habitable and probably are so I would suspect that the property is not worth what it's showing in the assessor's office. That would be my guess.
Commissioner Alford?
Ms. Freiberg, just a concern, I guess, if we go in there and clean this property up, okay? What's to prevent this guy from going right back in there and doing it all over again?
Nothing, once he's released,
That's
nothing.
my point. That's
Now,
my
there
point,
is, in the court order, he has, at least right now, he has been ordered that, there's filth, debris, and the housing conditions are livable, so he currently is not allowed to go on the property until it's abated. Now, once it's abated, though, there won't be any structures there for him to go into, but yes, your query is valid, which is he could go back on the property and mess it up again, essentially. Yes, and Commissioner Slater, I do have the answer to your question. I thought I pulled these, I just didn't recall. The property that has, the parcel that has the structure on it, he has the total market appraisal is $34,800. As I said, I suspect that is
Okay.
high. The other parcel is $6,500. So those
Okay.
are the two.
Thank you, I appreciate that.
Commissioner Hughes?
Crystal, by any chance, do you have any I know it went through criminal court, but I'm trying to figure out, and honestly, I know what some of the calls were, but I'm hoping that you know to help them understand why it went through criminal court.
Yes, and I was not at the original court hearing. I do know Tim Mason did testify. It's my understanding that there were calls related to overdoses. There were calls related to drug activity on the property, and I believe there was a deceased body at some point in time found on the property. So yes, lots of, and that is, in order to get it deemed a public nuisance, you have to prove all of those things. So, but I was not at that court hearing. That's just my understanding from the second hearing.
Thank you. Commissioner Blake, do you care to provide any sort of financial oversight or insight for us?
Well, you don't know how much it's going to cost, right?
I do not,
So
unfortunately.
the ones we've done before, I think was in the 10,000 range or whatever. So hopefully, whatever. But the other thing is you said it may not qualify for landfill money.
No, I think it would. It
Okay, I'm
doesn't-
sorry.
It would. We are allowed to use that for solid waste disposal, so I think that would qualify. It does not, however, qualify for our resolution where we said these are the parameters we're going to use landfill funds. We said in that resolution, which I think, if Lori wants, I think it's 2013-39. It's an older resolution, but we kind of set some parameters, and one of them was to keep Commissioner Alford's concerns from happening. We couldn't find any heirs. There was not a person on the property that was continuing to cause it, And so we had limited it to that. Now, we have on occasion gone outside of that sometimes, and of course, when we did, they came back a year later and the property was messed up again. So it doesn't qualify for our own resolution. That doesn't mean that it wouldn't qualify though.
All right, so we would use that bucket of money, that fund, that's fine. And I think you answered this, but just for clarity, we are obviously improving the property. And
Yes.
that was always a big thing, but the court order negates that concern.
Yeah, there's no legal concern with doing it if you go through the court process, because essentially we are improving it, but we're not giving it to him. We're putting a lien on the property saying, we want our money back if and when you sell it. So there would not be any issue with what you're talking about, which is the comptroller or somebody later saying that we improved private
Well,
property.
yeah, well, we had that with the tire thing, but just from a historical perspective, those that we have cleaned up, have we ever received any compensation back on anything?
We have on one, and it was one that we put the lien on years and years ago, and then it was finally sold through, somebody actually bought it at the delinquent tax sale, because that is what'll happen. I get the question, well, can't you just sell it? Well, you can, but the problem is we don't always have a buyer, and if we don't have a buyer, we're not gonna buy it, because I'm not gonna.
No.
I'm gonna say, no, don't bid that one in for the county. So then they just keep rolling over, and so, but we did finally have someone buy, and we did get paid.
We did get paid.
So it has happened one time. So to answer your question, I'm aware of one.
All right. Well, we'll roll the dice, I guess, on that. So, well, last question then is, what if we choose not to take action on this and, I wouldn't say ignore it, but, I mean, or do we
Well,
not have that
I'm not
option?
exactly sure. I think the court, because this, as I told you, this is an extremely unusual situation. I've never seen one go through this process. And so it's very unusual. So it doesn't happen very often. The DA's office was looking at some different options about how, because the statute doesn't really say who is supposed to do it. It just says it's supposed to be cleaned up and it's supposed to be ordered that it be cleaned up. So I'm not sure where the court would go from here if we were to just take the position that we're not gonna do it. I do think there's probably not anybody else that is gonna have the ability to. I think there could potentially be an ability for the court to maybe order some sort of sale of the property, but that's not gonna get it cleaned up. That's just gonna make it someone else's problem.
And I guess, I said that was the last question. To what extent do we clean it? I mean, like, just, I mean, I know what I think when cleaning is, but somebody else just says, we just need to get the trash off the ground, need to cut the grass, but
Yeah, we,
not paint the house kind of thing, you know what I'm saying? I mean, to what extent do we call clean?
when we do, if you all were to get to the point of having us get estimates, and as long as it's under 25,000, we can just get estimates, cost estimates, and then present those. But the order does say what we're supposed to do.
Okay,
As far as clean, yeah, I agree with you that it may not be as clean as some people would like, but it's basically taking abating the nuisance. So the structures that are dilapidated, they're falling down, the things that are causing the nuisance, and it does list in here, I think it says, let me see if I can find the
The number
language.
6, Crystal.
Yes, removing and destroying all debris, building structures, and materials. So that's pretty broad, and that is what I
Yeah.
guess concerns me from how expensive this one might be.
yeah, I mean, the
Because-
scope of work is, I
Right.
can do a lot
But
with that.
we would have a contract with whoever we
Okay.
agree to, and so
So-
there would be a scope of work. So that would be part 2 of all this.
So
figuring out
we would
exactly-
obviously use the landfill money. There is a line item for this that specifically for this, what we've tapped in before. So if the full commission eventually gets the full commission, and we go forward with this, an amendment would be to pull the money out of the fund balance and put it in line, and then the mayor's office would take care of the payment and all that kind of stuff.
Yes.
Commissioner Hughes?
The only question I have at this point is just, how are the taxes? Are they up to date or are they behind?
They are shockingly up to date. Yes, that was kind of the first thing that, yes, they have been paid. I suspect, and I think you all have heard me say this before on another property, a lot of times family members will pay the taxes for another family member so that they have a place to be and live. So it's very possible that, because I think someone else may have been paying the taxes. But yes, they are, it is not to the point where I could sell it for delinquent taxes.
I
Commissioner,
had one other question, Crystal. It says here, removal and destroying all building structures, materials and property and so forth. Does the guy own this stuff? Can we illegally go in there and take his stuff that he owns? Cause most time these places that we deal with are abandoned or something. This guy still has there, lives, and he still owns that property, and he still probably owns everything on that property. Can we legally go in there and take stuff away from him?
We can, only because the criminal court judge has given us the authority to. You are correct. Normally, you would not be able to. She did at the hearing tell him that there were certain things that he discussed about removing, and there was I think a wife or ex-wife involved that had some property there. So yes, that would normally be a concern. I do feel confident with this criminal court order that we would be able to remove anything from the property.
So we wouldn't be liable for any kind of suit if he decides he don't like the idea of us taking an old car away from him and ends up suing us, and criminal court that knows then, yeah, we told him you could do it, but
I think we're good on that, Commissioner Alford. We would not be if it were not a court order that gives us that authority. That's why that language is important.
yeah, but it doesn't list what we can take.
It does not, and I certainly am happy to on the next hearing date, if you all would like more clarity on that, we can certainly do that, because there will be a final order on this case. So we could definitely be more detailed about it. I will tell you, from my looking at it, it didn't look like there was anything of value on the property. There are.
Well, what's valuable to you may not be valuable to somebody else, so.
That's true, that's true. And I do think there's a fence that we actually made him put up when he went through environmental court that probably is still structurally sound, but that
Would it
might
be
it.
feasible, or, Mr. Collins, would it be feasible that if Ms. Crystal gets with the DA and see what he's thinking about doing, if we don't do it, or if we do it, what's the DA gonna do, or where does he stand on the whole situation?
Well, we have had those discussions, and that's what sort of precipitated all of this. The district attorney's office would like the county to take care of this
Yeah,
part
I
of it, for
figured they
sure.
would, yeah.
I don't know that they have a plan B if we were to say no. So,
That would be a good question. I think I'd ask a DA. If we say no, what's he gonna do then?
I can certainly ask that question.
I would like to hear that answer.
Commissioner
Thank you,
Blake?
Mr. Collins.
Yes, sir.
Maybe so, I think you might have just answered that, but as far as the criminal case of this, I mean, they've got everything they need out of there. Right, you said there was a deceased body, I mean,
Yeah, the criminal
that-
case portion of it, I mean, it has already been
we don't wanna go in there and
found.
muck up some evidence or something, right?
Yeah, there's nothing to, the court has already made a factual finding based on testimony and hearing that this property is a public nuisance. So it has been declared by our criminal court judge to be a public nuisance. So that decision has been made. Mr. Ratcliffe was there. He was able to provide whatever he wanted to say it wasn't. So that decision has already been made. It has been declared a public nuisance.
Thank you, Ms. Freiberg. Any other questions? All right, I'm looking for a motion on the abatement agenda item.
Make it.
Commissioner Hughes?
Second.
Oh, we have a motion. Can you make that motion? Can you state that motion, Commissioner Hughes?
Well, no, we need the abatement. What do we need the abatement to say? Basically, we're taking the money from the landfill, or? Funds?
Yes, I mean, the first step would be to move forward with getting cost estimates, and then
Alright.
the next piece would be so you could either do it all together, or you could separate that out. But the first piece would be to get the cost estimate. Second piece would be what Commissioner Blake talked about, which is to officially move the money and authorize. We usually do these by resolution, so if we were to do that, it would be a resolution talking about where the money's gonna come from and all the things about the property.
The other question, would you rather have that in two motions, or would you want that all together?
It doesn't matter to me, except for the piece that if you assume that the cost is 50,000 or higher than we thought it would be, I'm not saying it would be, I'm just saying if that cost estimate comes in really high, you all might want to have that information at some point, so.
Definitely.
Ms. Freiberg, would it be acceptable to, and I may pose this to Commissioner Blake, would it be acceptable to have a motion that subjects this to the Finance Committee before moving to the full commission?
Is there a time frame on action?
No,
Because part of this motion, if I understand, is going to be that you're gonna get more details on what exactly, so that scope gets a little bit narrow.
yes, I could certainly get more details on
I
the
mean-
scope, and then also, I'm supposed to report back to the court of what our plans are to move forward, if we have a plan. So whatever you all decide, I will report that plan to the court. I do think that getting the cost estimates is important, though. So I do think if we want to move forward, I do need some direction
And
for
that-
you all directing me to.
You're
to
the one that's
work
gonna
through-
get the cost estimates?
Indirectly, yes.
Of course.
Well, then,
Well,
what I can do is make a motion to where we will get estimates of what it's gonna cost to remediate the property, and then at that point, we will once you get that, refer it back to finance.
All right, so we have a motion on the floor. We
Second.
have a second by Commissioner Slater. Any discussion? No discussion. All in favor, say aye.
I had my hand up.
Sorry, Commissioner Alford.
Do we need a motion, and it's right now, Crystal, do we need to delay this until you can get further information, say from the DA and court and so forth? When they're having another hearing?
The next hearing will be on December the 12th at 1 o'clock, and that, I assume, will be a final hearing. Just not to make this more complicated, but if you all read the order, at the hearing, it got kind of unusual because Mr. Ratcliffe said that he had sold the property to his cellmate on the day of the hearing. So that did occur, and so we did give him an opportunity. So I don't know where all that will play out. There may be updates come December the 12th as well. So my response to that was if he sells it and that happens and someone cleans up the property before the county has time to deal with it, that would be fantastic.
That's
So
why I'd like to.
that is how I left that, so.
That's why I would
certainly-
like to delay until we hear all this information, then maybe we could come back with some kind of motion to move on.
Can I clarify, though, Commissioner Hughes's motion does provide that we get information first and then it goes to finance. So there would be an opportunity, I think, for a check on this if we continue with the original motion. Would that be acceptable, Commissioner Alford? And then it would still have to go to the full commission. Would that be acceptable? We have a motion, we have a second. Any other questions or
Read the
discussion?
motion.
The motion was to get
Lori's gonna read it.
no, I'm sorry.
When will you get your estimate?
It will depend on how long that takes, with the holidays. We have certain vendors that we've gone to, we've lost some of those over the years that do not do that anymore. But I will start working on it as soon as we can, and try to get at least three if we can. That's what under our policy, we're supposed to try to get three. So I will endeavor to get three. I don't know how long that will take. Usually they can go out and look at it and give it to you fairly quickly, so.
I just have a lot of concerns about this piece of property that we're gonna spend a bunch of money and we're not gonna get our money back. That's the bottom line, that any way you cut it.
I do like the idea that we're doing our fact finding, our diligence first, and then all of that information is going to our finance committee after that, before it goes to the full commission. So I think there will be multiple opportunities to ask questions and hear updates.
Does it need to go to finance or come back to this committee, then to finance for recommendation? Because he's gonna get a price with this, well, if this committee doesn't like the price, then it goes on to finance has to do something. Well, basically it is.
Well, are you making a substitute motion, or would you like to continue with the original motion?
No, I'm not gonna argue no more.
Okay. All right, we've got a motion and a second. We're all in favor, say aye.
Aye.
Any opposed? Motion carries 5-0. Thank you, Ms. Freiberg. Thank you for your commentary and questions. So we'll move into the second agenda item, item B, County Commission use of microphones during meeting streams. And I would ask Chairman if he would like to speak to this matter, and if he doesn't, that's fine as well.
Sure, my red light. I really don't have much guidance to give because there are 14 elected officials here, and hopefully they have the intelligence to know that you need to push a button for the red light to come on and push it for the red light to go off. I think we have a problem of oversight on the individual's part on whether the light is on or off. As far as when you're not talking, leave the light on, I don't necessarily agree with that. Sometimes the person next to you might be whispering something of a different subject or something, but I totally agree that when you're speaking, the light should be on. But that's just my opinion. I'm just one of 14 on that. I think I will have Lori give me a statement to read in the future on each meeting that the responsibility of the light being on when you're talking. I think I will do that as you did beginning of this meeting. But that's basically all I have as far as comment.
Thank you, sir. Any other comments or discussion?
Mr. Chairman, I think that's a good start, and that what Chairman Cry is referring to, a statement at the beginning of each meeting should apply to all the committees or any committee that's being done here in this. All of our committees meet in this room, but I think other committees, planning commission is what I'm thinking of, should also do it as well, because that's one that I watch from home as well, if not able to attend. So basically, a policy, basically the chairman of a committee read the statement that Lori will put in their agenda and ask all members to remember to turn the lights on or when we speak or whatever. I think that's a good start, and I think it'll get us where we want to be. So we want to make that a policy or a directive for Lori to put on the agenda, however you want to do it. But I think the chairman at every meeting before the meeting starts, reminding commissioners or whoever to do that right direction.
Thank you, Commissioner Blake. Commissioner Alford?
Yes, I need to see Ms. Poppin here. She's the one that initiated this conversation, I think. If you'd like to come up and say something, Ms. Poppin.
I wasn't planning on being here. I didn't know about this 2 hours prior to this, so I don't have all my details in front of me. I did start a petition about this roughly a month ago. I have not put in the full effort that I was planning on putting in to actually get this out to the public. So these numbers to me are embarrassing, but they do reflect some things I think you guys need to be aware of. One, I watch every single one of these meetings. I think you all know that. And there are times where it is human nature to forget to look for the button. Okay. There was an incident 2 weeks ago that the chairman actually forgot to push his button and was directed by another member of the board to actually click his button after 40 plus seconds had gone by and nobody could hear anything on the online stream. It is something that I think you guys really do need to consider doing. The idea that having a side conversation or quiet whispers are going to get caught. If you step back, and you saw this in in the public incident that happened not too long ago, if you step back even 6 inches from that mic, it is almost completely inaudible. You can't hear anything if you're not right up to the mic or very close to it. So I don't know that I agree with the statement that, side conversations are going to get caught on these live mics. If you are literally sitting back and needing to have that conversation, it does not get caught. The petition I created does have 90 signatures on it. I made an effort because I know that in a lot of these cases, these petitions get brushed off as being not valid because a lot of these signatures aren't county residents. I took the effort to actually go get the voter roll and document each one of the signatures that I get visibility to on the back end. 70% of these 90 are active Bradley County voters, not just people that are just, sitting on the sideline. They voted in the last 2 elections. So not only that, but if you look at the views on that petition, I think they speak louder than the signatures for a couple of reasons. 836 views on that petition. The reason I think that they don't equate to actual signatures is because a lot of people are scared to put their name on something that's political because of the political climate we have. I had more than 20 people tell me, and some of them were Bradley County employees, tell me they absolutely agree with this petition. They want these mics live from the time that we do prayers until we adjourn so that they don't miss things that are important to them. And it's human nature to sometimes forget to push your button. I'm not blaming anyone. There are some habitual offenders of this. I'm not going to point them out. To me, that makes no difference. It needs to improve, and this is a way to make it happen with very little impact to all of you. So you have the numbers there. You see even what district has the most votes. Ironically, one of the offenders has one of the highest votes on this petition. So I would encourage you to consider taking this up as a motion.
Thank you, Ms. Popple. I'll say this, I appreciate your engagement with the commission and with the community at large. I mean, it's, regardless of the opinion, I think it is important and significant, so thank you for that. Any other comments or discussion, questions? Is there a motion to be made here? I know Commissioner Blake made the comment that was specific, and Chairman Cry made a comment recognizing something similar to what I read at the beginning. Encouraging individuals to be reminded to keep your microphone on. I know there are some technology issues and some issues with having the mics on simultaneously. I believe this is kind of one of the concerns with these mics. Having them on simultaneously does create a feedback issue, or can create a feedback issue. I'm not real sure how technologically sound our Audix boxes are here, but is there a motion to be made that might be a step in the direction to support this?
I think it's just, we're asking Lori to put this on the agenda. I mean, we don't have a motion to put the pledge or to have a pledge, but it's on the agenda. So from here on out, just is a reminder to the chairman of the full commission or committee to do it. But a policy, I think we'll start here, and if we need to, we'll come back to a policy, but just ask Lori to put this on all agendas. We have, every one of us gets this for our agenda. Finance gets it, I think, education, law, fire, and call to order, and then make your reminder part of the agenda template. I think that'll get it done.
Thank you, Commissioner Blake. Ms. Freiberg, any comments to that in terms of procedural issues?
Yeah, I mean, certainly that is something that you can do. The only thing I will say, you certainly can put anything you would like to in your policies. I'm not sure, though, what the recourse would be. I mean, certainly the chairman is responsible for trying to enforce the rules, but Chairman Cry doesn't have any ability if someone doesn't turn on their mic. I don't know what he would do if it's in policy and then someone fails to turn on their microphone. I mean, Chairman Cry doesn't really have any legal authority to do anything else, I guess, if that makes sense.
Yeah, I agree. So in other words, if you have a policy, then you're also going to have the accountability.
Correct.
And good luck with that. But having it on here and the reminder for every meeting, I think may take 1 or 2 meetings, but then it'll become habitual.
Ms. Moultrie, I'll defer to you. Is that something we can add to each of our agendas? Okay, outstanding. We'll do that. So if there are no other motions, no motions or no other comments or discussion items, we'll consider that closed, and we'll move on to item 5, other business. Any other business? Commissioner Blake, you're recognized.
Thank you, Mr. Chairman. We have a policy with respects to, how the county commission handles interlocal agreements. We have, I think, two of them kind of in the, works right now, that they have to go through two working sessions. And I have found that time valuable. 'Cause we've had resolutions where they get introduced in a work session, and the following Monday we're voting on it, and I would like to think I had the time to do it. So knowing that I really like that, and I'd like to put it, I guess the thought for a second, and then maybe a motion that we pilots that come from the IDB board, and now we know that TIFs are going to be coming as well, that they also go through two work sessions. So they get introduced in work session one. That gives all the commissioners and anybody interested the ability to start their research. And then in the work session two, you can start asking questions, get insight and stuff like that. And then after that, go to a voting session. So yeah, it may take a little bit longer, but I think the end result's going to be better, will be better for it. And those who are introducing the pilots and TIFs, if we put this in place now, they'll have their timeline. We talked about timeline quite a bit last night, you know. They can, like, if I need this done by the end of January, backdate it to, okay, I gotta go through two work sessions and so forth, so they can plan accordingly as well. So, I just think after this, when we had these interlocal agreements and having the two work sessions, has been valuable, and I'd like to have that same amount of time for pilots, and we all remember what pilots are, and the TIFs that may be coming as well.
Would you like to put that in a form of a formal
That's-
motion?
Yeah, so if we can get discussion. So, Mr. Chairman, at this time, I'd like to make a motion that, effective immediately, any and all pilot agreements and TIFs that are presented to, committee or, well, to the full commission, are required to go through two full work sessions before voted on.
Or we have a motion. We have a second by Commissioner Alford. Any discussion? All right, very good. Seeing no discussion, we'll take a vote. All in favor, say aye.
Aye.
Any opposed? Motion carries 5-0.
So this will have to go to the full commission, but
That's correct. We'll propose that to full commission. Thank you, Commissioner Blake. So, moving on from other business, before we open the floor for communication from the audience, I'd like to remind any individual wishing to speak of a few guidelines. Please begin by stating your name and county address for the record. Speakers are also asked to direct all comments to the commission as a whole and not to address individual commissioners by name. Each speaker will have 5 minutes to share their comments. Thank you for your participation and cooperation as we work to maintain an orderly and respectful meeting. At this time, is there any communication from the audience? All right, very good. I believe no announcements, so at this time, we'll adjourn our meeting. Thank you very much.